Hello, my name is Nicole Braddock. I'm an attorney with the law firm of Murray, Plum & Murray, and I'm here with Dick O'Mara, also an attorney at Murray, Plum & Murray, and we're going to talk to you today about complaint investigations. So you know, complaint investigations are one of three dispute procedures that are provided by the main special education regulations as well as the IDEA. The others are a standalone mediation as well as due process hearing. Those will be covered in other videos that you can find on this website as well. So we're just going to focus on complaint investigations, and the question is, what is a complaint? A complaint investigation is a process that you can use to address one of several issues that arise with respect to a child's education, any dispute regarding the identification, evaluation, placement, or provision of appropriate services to a child. Now, this can be your own child, but the regulations also permit third-party complaint investigation requests. We'll talk a little bit, Dick will talk to you a little bit about the actual complaint investigation procedure, but generally when you wish to file a complaint investigation, there's a form that is available both on the Maine Parent Federation's website as well as the Maine Department of Education's website. It's called a dispute resolution request form, and there's a place here to check that you are seeking a complaint investigation. There is also the opportunity to participate in a mediation if you seek a complaint investigation, and you can check the appropriate box here. There's another video that speaks specifically to mediation, so you may want to check that out if you're interested. The dispute resolution request form requires you to fill out the specifics of the child at issue, the school district at issue, and to state what the problem is. And you want to try and be as specific as possible about what the issue is. And there's a space here to describe the nature of the problem, and that's really where you want to talk about what you're seeking, what the issue is. How could this problem be resolved is another area where you need to fill out, and that's the area of what are you seeking? What are you looking for? Are you looking for a new IEP? Are you looking for the IEP to be implemented appropriately? Are you seeking a child to be identified as a child with special needs? And then number seven on this form is, what action has the school taken to address this problem? So if you have raised the problem with the district and they have done nothing, or they've done something but it's not enough, that's where you would put it there. So an example of when you might want to file a complaint, these typically, a frequent one is when there's an issue with compliance with the IEP. So you have an IEP and the district is not following the IEP, or they're not implementing it faithfully. That's a good one for a complaint investigation. If there are more general policy issues with the district and you don't feel they're following the IDEA, that might be another good one for a complaint investigation. The complaint is fairly simple to fill out, and the procedure is one that you can really do without an attorney if you can't afford an attorney, because it's really driven by the complaint investigator and by the person who's making the complaint. And Dick will talk to you a bit more about how the process really works.
So once you have filed your dispute resolution form with the Department of Education, what's going to happen is this: a complaint investigator is going to be appointed by the commissioner, and you'll get a letter saying who that person is, and it will also tell you how to communicate with the complaint investigator. As the complainant, you are allowed and encouraged to provide information that's beyond what you put in the dispute resolution form. Think of the dispute resolution form as a summary that lists out the areas in which there are disputes or the potential resolutions you'd like to see. But as all of you know, there's going to be other documentation about the child at issue, perhaps evaluation reports, IEP documents from the current year, maybe from the past. There usually are written notices from the team meetings that have been held about the child, and there may be other information about private services that the child has received, or other issues that have gone on in the child's lives that will affect the resolution of the complaint. You should compile your documents and make sure that the complaint investigator sees those documents and has access to them. The complaint investigator also is allowed to do on-site visits to the school district and to look at the child's records at the district. And so that's another way the complaint investigator will compile and have access to information. The complaint investigator also is allowed to talk to witnesses. So there may be certain people that you want the complaint investigator to speak with, either in person or on the phone, as they do their work. Remember, this is the model that's being used for a state complaint investigation is sort of a private eye model. This is one person who's charged with going out and collecting all the facts. And so to the extent that you as a complainant can help that person by saying, these 3 people all evaluated my child, and they all can tell you about his needs. Here's their phone numbers, and here's times they're available. That's very helpful to the investigator. You're allowed, as the process goes on, to talk to the investigator yourself, either in person or usually on the phone, to answer their questions, to make sure they have all the information that they need, to make sure that they've been able to reach the people that they need to speak with, so they have full and fair information in order to make their decision. The one thing that complaint investigation does not offer is any chance to cross-examine. In other words, if the complaint investigator goes and speaks with the staff at the school district, the parent is not there when that happens and is not allowed to ask questions of the school people when they're talking about the child. By the same token, the school is not present when the complaint investigator is talking to the parent or the parent's witnesses that have been identified. And so each side is giving its information a bit in a vacuum to the investigator, and it's up to the investigator to decide who is credible, who has the better information, and sort out, without any opportunity for the sides to cross-examine each other about the information that they're providing. At the end of the process, which can take only 60 days, the complaint investigator writes a report going through the basic facts and also talking about each issue that you have raised in your complaint, and says what the resolution of that issue should be, either in favor of there being a violation or saying that there's no violation. After answering each of those things, the investigator may suggest a so-called corrective action plan, which Nicole will speak about in a minute, that addresses any violations and talks about how they'll be remedied. That report, however, is not what's given to you. The state complaint investigation is just that. It is the state that is deciding your complaint, not an investigator. So the investigator has to turn that report into the Maine Department of Education. It is then reviewed, often by someone in the Attorney General's office and by the Commissioner's office. And so the letter that you get at the end of that 60-day process will come from the Commissioner, and it's the Commissioner's decision. I say this because we have had cases in the past where the recommended decision from the investigator is different from the one that actually is issued by the Commissioner. So the report could change once it's submitted to the state educational agency, which is, in our case, the Maine Department of Education, before you actually get it. One other thing to mention is how far back in your complaint can you go when you raise issues. This has been, in the federal law, it says 1 year. And in the past, state law has said you can go back 3 years. In the last year, this has been resolved. We now have a rule that says that you can normally go back 1 year from the date that you file the complaint in pinpointing violations that you'd like to see addressed. But if you're asking for compensatory services, you can go back up to 2 years from the date on which you file the complaint. This is important to know because if a certain situation has been ongoing, it's been a chronic problem in the child's education for the last 2 years, you can seek relief from the complaint investigation that covers the entire 2-year period in which you think there's been a violation of your child's rights.
One of the most important rights that you have with respect to any of these resolution procedures is your stay put right, and that exists with complaint investigations as well. What that means is that when you file a complaint investigation, your child's placement at the time you file the complaint investigation cannot be changed. The district has to continue to maintain that placement until you get a resolution of the complaint investigation. If one of the issues, for example, is that your child is in a private placement and the district is proposing to move the child to a public placement, during the pendency of the complaint investigation, your child has to remain in the private placement until you get a determination from the complaint investigator. It's a really important right, and one that you may want to specifically invoke in your complaint investigation request. As Dick mentioned, when you get the determination from the commissioner and from the complaint investigator, one of the things it can include is a corrective action plan. What this means is if the if it is found that there was that the district had some sort of violation of the IDEA or the Maine special education regulations, how are we going to fix it? This can cover a wide array of things, and is parallel to what a hearing officer could award you in a due process procedure. So, for example, if the issue was identification and you brought a complaint investigation seeking to have your child identified as eligible for special education, the corrective action plan can require the district to find the child eligible, or it can require the district to conduct evaluations, or it can tell the district to amend an IEP to include certain services, to train staff, to implement the IEP faithfully, all sorts of things. You know, there's a sort of a wide range of possible corrective action plans. If a corrective action plan is included in the determination, the district has an obligation to communicate directly with the State Department of Education to let them know that they're following the corrective action plan, and the corrective action plan is monitored by the Department of Education. And I think that pretty much covers complaint investigations.